Welcome to the video. First, we will set the stage by explaining why F-1 status is fragile and how a sudden change like dropping out can trigger immediate immigration problems. Next, we will connect that risk to the potential solution through marriage to a U.S. citizen and the adjustment of status process. Finally, we will outline a safe, step-by-step strategy, highlight pitfalls, and end with key takeaways and a quick quiz to test your understanding. Here is our roadmap. First, we will cover the stakes for F-1 students considering dropping out. Then, we will explain how F-1 status operates and how marriage-based adjustment of status works. After that, we will reveal a conservative timeline and step-by-step plan. Next, we will outline costs, common risks, and myths. We will also touch on special situations. Finally, we will test your knowledge with quick quizzes and end with key takeaways. Before we go further, an important disclaimer. This content is for educational purposes only and does not constitute legal advice. Immigration outcomes depend on specific facts, documents, and history. You should consult a qualified immigration attorney, especially if you face imminent loss of status or unique complications. We will discuss general rules and practical strategies, but your case may differ. Now, let us discuss the stakes. F-1 status depends on continuous, full-time study. If you drop below full-time or stop attending, your authorization to stay ends, and you become out of status. At that point, you face serious risk, including potential removal proceedings. This is why timing and paperwork are critical if life changes lead to marriage to a U.S. citizen. The adjustment of status pathway can help, but only if executed carefully. Let us clarify core concepts. First, F-1 status requires full-time enrollment and adherence to school and immigration rules. If you drop below full-time or stop attending, you become out of status immediately. Second, marrying a U.S. citizen may provide a path to adjustment of status. Immediate relatives who entered the United States lawfully, like most F-1 students, are frequently permitted to file for AOS, even if they have certain status violations. Third, timing is crucial. A conservative approach is to remain enrolled until your I-130 and I-485 filings have been accepted and receipt notices have been issued. Finally, do not leave the United States while the I-485 is pending unless you have valid advance parole, because departure can be treated as abandoning the application. This timeline illustrates a conservative, safer sequence. First, a decision to marry is followed quickly by a civil marriage. Next, within 1 to 2 weeks, the couple prepares a complete concurrent filing, including the I-130 and I-485, as well as the I-864, I-693 if available, and applications for work and travel authorization. Then, the package is filed, and within several weeks, receipt notices arrive. After receipts are in hand, if staying enrolled is no longer feasible, a formal withdrawal can occur. Subsequently, biometrics is scheduled, followed by the potential issuance of a combined work and travel card. Eventually, the local field office schedules the interview, which culminates in a green card decision. 2 critical notes are emphasized. Remain enrolled until receipts if possible, and do not travel outside the United States without advance parole while the adjustment is pending. Now let us convert strategy into action. First, formalize the marriage promptly through a lawful civil ceremony. Second, assemble a complete concurrent filing, including the I-130, I-485, and I-864, with the appropriate fees, and typically the I-765 and I-131. Third, collect strong evidence that the marriage is bona fide, such as joint leases, bank accounts, photos over time, affidavits from friends and family, and communication records. Fourth, file a clean, accurate package with the correct fees and copies as required. Fifth, if possible, remain enrolled until the I-797 receipt notices arrive. Sixth, if continuing enrollment is not feasible after receipts, formally withdraw from school. Seventh, attend biometrics and respond promptly to any request for evidence. Eighth, prepare carefully for the interview and bring updated documents. Let us compare 2 paths. On the left, staying enrolled maintains lawful F-1 status while the filings are processed. This provides time in case of administrative delays and may present a lower risk profile at the interview, though it can result in additional tuition cost. On the right, dropping out immediately creates an instant out-of-status situation. In that case, you must marry and file for adjustment without delay, relying on the protections afforded to immediate relatives who entered lawfully. This approach carries higher risk because there is little margin for error or processing delays. Here are typical costs and timelines. Government filing fees change, so always check the USCIS website for current amounts. Civil marriage license fees vary by locality. The medical exam cost depends on the civil surgeon and region. An attorney consultation can add cost, but it may prevent costly mistakes. Work and travel authorization timing varies, often several months. Interviews can take months to over a year, depending on local field office backlogs. Let us examine common risks and myths. First, traveling outside the United States without approved advance parole while an I-485 is pending can result in abandonment of the application. Second, although certain status violations and unauthorized employment can be forgiven for immediate relatives who entered lawfully, whether that applies depends on case specifics, so legal advice is essential. Third, the process is not necessarily cheap or simple, and filing errors can lead to delays or denials. Fourth, leaving the country during the process may force consular processing and add new risks. This should be avoided unless a qualified attorney advises otherwise. Fifth, intent and relationship authenticity are key. You must prove a bona fide marriage and never engage in a fraudulent marriage. Finally, policy and processing timelines change, so verify current rules with official sources. Now, a brief note on special cases. Some applicants experience additional security screening that extends processing times. Any prior immigration violations or criminal history can complicate adjustment and should be reviewed with counsel. Past misrepresentation, fraud, or false statements may trigger inadmissibility and require waivers, so legal advice is critical. If continued enrollment is impossible, file immediately after marriage with a complete and accurate package to reduce risk. Quiz time. The question is, what is the safest order of actions if you can still remain enrolled? Option A, drop out, then get married, then file later. Option B, get married and file the I-130 and I-485 concurrently, then consider withdrawing only after receipt notices arrive. Option C, leave the United States and process at a consulate immediately. Option D, wait for an employment authorization document before stopping classes. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is option B. Get married and file the I-130 and I-485 concurrently, then consider withdrawing only after receipt notices arrive. This approach maintains status during the most vulnerable period and reduces the impact of filing delays or errors. Second quiz. The question is, can an F-1 student who fell out of status still adjust status after marrying a U.S. citizen? Option A, no, never. Option B, yes, in many cases, if the student entered lawfully and is an immediate relative, despite certain status violations. Option C, only if the F-1 is reinstated first. Option D, only after leaving the United States to process abroad. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is option B. Immediate relatives who entered the United States lawfully can often adjust status despite certain violations. However, nuances and exceptions exist, so consultation with a qualified attorney is recommended. Here are the key takeaways. Timing is critical because F-1 status ends when full-time enrollment ends. Marriage to a U.S. citizen combined with concurrent filing can be an effective solution when executed correctly. A conservative approach is to stay enrolled until receipt notices arrive. Do not travel without advance parole, and avoid triggering consular processing unless advised by counsel. Finally, prioritize accuracy and consider legal guidance to prevent avoidable errors. To summarize, understand that F-1 status is fragile, and that immediate relative adjustment can offer relief when entered lawfully. A conservative strategy that prioritizes receiving USCIS receipts before withdrawing from school can reduce risk. Finally, avoid pitfalls such as traveling without advance parole or submitting incomplete evidence. Thank you for watching. To continue learning, please like this video, share it with someone who might benefit, and subscribe for more practical immigration guides. We would love to hear your questions and experiences in the comments, as your insights may help others facing similar challenges.